TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision. I don't believe you have paid. I don't believe you've posted your appeal bond. Then you filed some motions for today, but the main concern is you need to either pay or appeal, perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file. Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that notice of appeal. So you started the appeal process, but typically they don't accept those until or unless accompanied by an appeal bond. And you did not pay that cash bond, did you?
No, I didn't. I actually did the properest, and I got a letter from the appellate court, and they said that I needed to be signed. I sent it in, but it needed to be signed, so I submitted it. As soon as I got it, I submitted it to your office, and then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason, it didn't go, but if I get the signature, then I'm.
Buckle up, guys. Today, we're diving into the courtroom chaos of a Kansas sovereign citizen named Abel Estrada. Convicted of driving around with a bogus license plate from a sovereign scam vendor, Abel now wants Kansas taxpayers to fund his appeal. That's right, he bought fake plates, got caught, lost in court, and now expects a free ride on the state's dime. This video kicks off in Greenwood County's District Court, and the judge isn't buying what Estrada is selling. Get ready. This one's a mess from the judge.
As motion to proceed in form of papyrus, I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well, apparently, Mr. Dean, that's up to the district court to make that determination on an appeal. I would have thought the appellate court would have made that.
That would be my understanding as well. I don't know what letter Mr. Estrada is speaking of. We don't have anything. I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or the initial complaint, you get a copy of it, etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case, and let me see.
If I may.
Well, I show the journal entry of trial. Let me see if it was filed February 21st. And that shows that he was found guilty of displaying unlawful tag.
I think he's still within his 60-day docketing time period. So
I think so too. So Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the, sorry, this one. I just needed the signature on the papyrus, form of papyrus. I don't know if you can see it.
No, we can't. Why don't you read it to us, Mr. Estrada?
Oh, I don't have my glasses. Well, can you read it for me? I have my wife because I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark.
Hey, ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muffled sound. I can't really tell you.
I can't track it. If you get in front of the camera.
Here's where things start to unravel fast. The judge reminds Estrada that not only was he convicted, but he hasn't paid a dime toward his appeal bond. Instead, he's tossing in last-minute motions, hoping to bypass responsibility. Estrada tries to argue he's perfected the appeal, but without a signed indigency, order, or payment, he's just spinning wheels. The judge is done playing. If Estrada doesn't pay, his license is headed straight for suspension. This courtroom isn't a playground. And Estrada's about to find that out the hard way.
You have a document in front of you with the Court of Appeals. Okay. If you'll slowly and loudly articulate that, because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the
pertinent part.
Okay.
Body of the letter, where
Okay.
it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in form of papyrus, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf for a period of 6 months pending receipt of the items noted above.
Things heat up as Estrada admits he didn't pay the appeal bond, but claims he filed improper, proper paperwork, whatever that means. Then comes the curveball. He couldn't get a signature and sent in unsigned documents. The judge and prosecutor are baffled, flipping through filings that make little sense. Estrada also failed to notify opposing counsel, a basic legal requirement. His pro se game is sloppy, and everyone in the courtroom knows it. He's drowning in paperwork he barely understands and trying to appeal with nothing.
Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Which I already did.
Clearly you haven't, sir, because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you file with the Court of Appeals.
I
They specifically,
Don't interrupt him. Let him finish.
they specifically advised you that you had not. And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it. I mean, it doesn't, I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform and under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So, motion to dismiss liability.
Now things get truly surreal. Estrada's wife, Annie, jumps on camera to read a letter from the appellate court. It's a checklist of everything Estrada hasn't done: no signed indigency order, no transcript request, no fee payment, no proof of service. And get this, he's trying to extend the deadline before it even passes. It's the legal equivalent of running a race. Without shoes or pants, the court is bending over backward to explain basic steps, while Estrada and his wife flounder with overdue forms